And as I mentioned, of course, today in the market, we turn our focus on what is happening with the judiciary. As I mentioned earlier as well, they will be marching from Milimani Court. Those are lawyers, advocates also of the High Court, to the Supreme Court to actually protest what has been happening lately, especially with the startly, disregard of court orders from police as well. Allow me to introduce our guests to you this morning and mention them just as we're beginning the program. We have with us Karanja Kabage, who is an advocate of the High Court. Also, we do have with us Professor George Wajokoya, who is an advocate of the High Court as well, and also a lecturer of law at USIU, Faculty of Law. And also, we do have with us Apollo Mboya, also an advocate of the High Court. We're still waiting for the rest of our panelists to join us. But that story really acts as a segue on our discussion this morning, looking at the state of the judiciary here in the market. And I would love to hear from our panelists this morning just to tell us what their thoughts today. First of all, we'll begin with this particular walk that will be from Milimani courts to the judiciary. Let's hear to actually the Supreme Court. Let's hear from Karanja Kabage if he actually is on this particular walk this morning. You don't look like someone who's actually prepared to be walking from Milimani courts to to the Supreme Court today. Looking dapper in the tie, very smart. Yeah, all of you. Save maybe for Apollo Mboya, who's not really donning a tie today. Yeah. Let's begin with you.
Thank you, Debarl. I think protests are allowed in our constitution, and this is not any different from any other protest that can be mounted by other fellow Kenyans. Mm-hmm. And it's good that we have this opportunity as provided for in our constitution, that we are allowed to protest, picket, in a way expressing displeasure mm-hmm. for what we perceive to be not in the interests of justice.
Yes.
And I think that is allowed.
Mm-hmm.
But I'd like to say something regarding lawyers. We have a number of different lawyers in the country who practice law differently.
Yes.
We have court lawyers,
mm-hmm.
A very small minority that go to court. But majority of the people that practice law, you hardly find them in court.
Yes.
But because of the glare of the press, one tends to think that the practice of law is only a preserve of those who are in court. Certainly not. There are thousands of lawyers. I probably believe maybe 5% of our lawyers go to court. Mm-hmm. The rest don't go to court. But I think for me, what I celebrate is the right and the freedom of any Kenyan that wants to protest to do so unfettered. Mm-hmm. And I think that is really something that we should all encourage, so that the citizen can feel free to go about their business without being harassed by anybody. Mm-hmm. And protesting is one of those actions that are provided for in our constitution.
All right, but perhaps the abiding question remains, why are they protesting? That's the question.
I think you read yourself. You said that...
I did, but I want to hear from you. Hmm? I read it, yes, but I want to hear it from you.
They're protesting against what they are calling, impunity with respect to court orders. Mm-hmm. That's what they're protesting against, yes.
All right, from your own estimation, do you think there is impunity?
Let me put it this way, and I want to make a public declaration. Mm-hmm. I owe fidelity to the rule of law. Mm-hmm. And I'm one person who believes that this country, we must adhere to the due process and the rule of law. And I therefore support the whole idea of making sure that the country obeys the rule of law, mm-hmm. and court order is one of such requirement mm-hmm. to validate our fidelity to the rule of law.
Yes.
Therefore, that's what I believe in.
Thank you.
Yeah.
All right, let's hear from Professor Jojo Wajakoya.
Thank you very much, and I would like to take this opportunity to thank Mr. Kabage, our senior counsel. I admire him so much. I've read so much about him. I've never met him in person. And thank you, Inea, for making me to sit just even next to him. It's a privilege. I would also like to thank Mr. Paul Mboya, a man of honor and a former CEO of our law society. And as I speak today, had I gone to school earlier, like others, maybe I would have been ranked among them, but I went to school at the age of 34 after having struggled, like my dear friend and the new Minister Rashid, whom I should thank and thank the President. But having said so, the issue of boycotts and the issue of freedoms, fundamental freedoms, as enshrined in the Constitution, goes way back to 1215, during the Magna Carta Treaty, when there was dominance of religious leadership, particularly the Catholics, when there was dominance of fiefdom, where the barons who owned land and slaves were exerting pressure on their servants, as we may call, and in which case there was chaos, disorders, and there was no common sense. Magna Carta Treaty is the founding treaty of human rights, rights of individuals, rights of people. And as lawyers, we are actually premised to speak from the same script. We are the custodians of liberty. And where there is grave disrespect to human rights by the government, the executive, or those insubordinated or subordinated by the executive to take certain matters up front, then we shall come out very clearly. And I must also take this opportunity to thank Mr. Mwamu. Mr. Mwamu made it very clear, especially when the current chair to the Law Society came up with this proposition that lawyers were going to boycott, leave alone protest, boycott the courts. What he said, and what I agreed with, is that there was no consultation up to that particular level. And that also, I mean, he came out very clearly on K24 to say, look, it's a good thing, but we have not been consulted, and we need that consultation. And as such, the chairman had to come up to this issue of protests. Where society is governed from the days of Mosaic law, with the introduction of Mosaic law, then the constitution which comes in to set precedent must be followed to the letter, though not absolutely. But the Inspector General of Police has no right in law. The Director of Criminal Investigation, who is my friend, so is the Inspector General, they have no right in law to diffuse of their offices which are granted under the Constitution. And let them be put on notice that disobeying court orders is worse than murder. It's a crime against humanity.
Crime against humanity, right? Worse than murder. Apollo, good morning.
Good morning. Thank you.
Yes. So are you working today? Are you marching to the Supreme Court for Milimani Court?
Oh yes, I will march. I will march because it's a clarion call that has come from the national office, and we have a duty. Unlike Mr. Kabage, I go to court. And I have a matter today. That's why I'm dressed like this.
Okay.
Yeah, just before the march.
Yes.
But the most important thing is that there are two things that are going to happen apart from the march. The first one, this is an important decision. I'm not in that matter, but this is an important decision today in court, where the Inspector General of Police and then the DCI, the Director of Criminal Investigation, and also the Director of Immigration are supposed to appear in court to be tested on the question of contempt of court. So that one fits very well with what's going to happen today.
So this is in regard to deportation of Miguna Miguna as well. Okay.
Yes.
So that will be happening today as well.
Today.
Okay.
As well, because what the march we are talking about, it's actually a procession. It's not a boycott. It's a procession.
It's a procession.
It's just a procession, because as legal professionals, also we must we do our things differently. It's a procession, and we've done it before during even Rachel Omamo's chairperson's tenure. So the most important thing is the rule of law, because the alternative to it is chaos. If people do not obey court orders, what we will be witnessing is something that I cannot even want to start imagining, because you are then telling the public that you cannot go to court in order for your dispute to be adjudicated. Then take law into your hands. That is the converse of disobeying court orders. And that's a very worrying trend.
All right.
Yes.
Okay, and of course we shall continue this discussion much later in the course of the program with our panelists here. Page 4 of the Daily Nation is having a very comprehensive story on why also we think, or yes, we know that the Jubilee administration is going for the jugular as far as the judiciary is concerned. Tuju accuses Maraga of a double standard, it says. And what is alleged also, you have a snippet of that. Supreme Court has displayed bias, it says. When the Supreme Court nullified the August 8th elections, the Jubilee government obeyed the orders, but NASA chose to defy the ruling. And also it says the judiciary issued no statements to condemn this NASA defiance of the rulings. So that is what we shall be discussing much later with the panelists here in the course of the program as well. And also the early retirement of Attorney General Githu Muigai. What does that portend, especially for that particular office? And do we have also Judge Kihara, really coming in to clean the house, or what is really pending for him as far as the entry is concerned? So let's continue the conversation at pace, right? Before we took a short break, we were looking at why people are marching. And of course, this is really pegged on what really happened and the handling of Miguna Miguna's case. And I think that's why we're having this procession this morning, because we've seen a total disregard of court orders from, some of the government officials. And of course, we know for any country to work seamlessly, even the institutions need, the interface of institutions need also to be seamlessly flowing. So if maybe there is some fraction, there is some ruffling of feathers in between, that is bound to, make the whole system really be gummed up. So let's just begin from you, Apollo Mboya, first of all, because I know this whole saga is predicated on the deportation of Miguna Miguna and the way he was handled. And you, as a faculty, or the lawyers, of course, your fraternity is also fighting for your own as well.
Yes, let me make it clear. The court orders that have been disobeyed are many. So the one with respect to Miguna Miguna was just one of them.
But was it the tipping point for all of this as well?
I think it came at a time when there was enough coverage to make the public realize how blatant and how contemptuous the institutions and individuals in government can disregard the orders of the court. So I think that is the only difference. Otherwise, there are several court orders that have been disobeyed, and not only by individuals who are in government, but also private citizens. Some of them obey court orders. But in this particular instance, it coincided with that big issue, because the question that we're talking about with regard to Miguna Miguna is very weighty. It's a question of citizenship, and also it's a question of his fundamental rights. So I think that is why it's been magnified. But again, that is the one that I can say the media focused on, if you look at that. But the most important issue is that if you look at even in the history of the judiciary, there's been a plethora of court orders that have been disobeyed. Contempt, we could even see, if we look at in the recent, when the question of presidential election came into being, there was the question of, remember, open the server, IBC not doing what the court said.
Yes.
Now we have seen Tuju in a letter also claiming that there are certain court orders that he felt were not obeyed by NASA. So you can see all these accusations, and actually he is even saying that he feels that the judiciary has been lenient towards NASA or biased towards NASA. So all these are there, and the procession today is supposed to recalibrate the whole issue of the rule of law to ensure that we can go to the judiciary as an arbiter in dispute, and that everybody, regardless of who you are, must respect the decision of the court if you want to have law and order in the country.
All right. Let's hear from Karanja Kabage on this as well. So we're asking, did Miguna's case brought about the tipping point that we can see, yes, also the lawyers now, they're actually having this particular possession. And of course, why is there a total disregard of the law, especially in this epoch of time that we're in, where we need to have, you know, the institutions working?
Well, from my perspective, I think it should be an established norm and practice that court orders must be obeyed by each and every one of us. And the judiciary should be in the forefront of making sure that court orders are disobeyed by every citizen, every institution.
Obeyed or disobeyed?
Obeyed.
Okay, thank you.
Obeyed. That is the only way, therefore, or thereafter, you can talk about the rule of law and the due process. And it doesn't matter whether the court order is in your favor or otherwise. That should be an established rule. There should be no day and night between all of us on this platform, that any one of us is in favor of disobedience or flagrant disregard of the rule of law. Because the moment you do not obey court order, then we have a very serious problem. Because what is the alternative? It is to gastric to contemplate. So we shouldn't be having any differences as far as that issue is concerned, and it should be across the board. For instance, if you make reference to even what Tuju is talking about, and I said it in this station, I was being interviewed just prior to 2017 October 26 general election. I said, I'm wondering why there should be an issue between Jubilee and NASA as far as going for these elections are concerned. Because Jubilee did not issue orders that there should be a repeat of the election. This was a direct Supreme Court decision that said, according to Article 140 of our Constitution, that there must be election of the president, re-election of the president on the 26th of October.
Yes.
So, and I said at that point in time, I said, and it is on record in this station, that it is a flagrant disobedience of the Supreme Court order by NASA to campaign and even to stop people from going to vote. Because first of all, saying you cannot even vote, it in itself, it is against the Election Act. Nobody should stop you or persuade you from going to vote. Now, I didn't hear anything from the Supreme Court or the court saying that our order are supposed to be obeyed. So in this respect, it is everybody who must. Those who issue orders and those to whom orders are issued must pay great respect to the obedience of the court order. So it is important, and it's both parties, those who issue court orders and those to whom court orders are issued against.
Okay.
Yes.
All right, but I think also the fact that we have now this toying and froing, between NASA and Jubilee, and now the judiciary being, caught in between, in the center and the smack dab of the middle of all this, maybe it epitomizes what truly we are in as a state and the judiciary, right, so to speak, right now. And that's where I want us to drill deeper, just not to really focus or have a myopic view that it is here NASA against Jubilee. As a country, right, are we seeing the state of judiciary under threat, especially from the executive? Because we know all these institutions, when you talk about police, when you talk of the director of criminal investigation, when you talk of NIS, all this, of course, they take orders from the executive as well. Let's just hear from you, Professor George Wajakoya. First of all, the whole handling of Miguna as aligned with the Constitution, and of course allegations or maybe reasons being advanced that yes, he's actually in the country not, or his citizenship he had revoked that, which he has totally denied. You as also an immigration lawyer, maybe you can also put all this into perspective as well and throw in the state of the judiciary as well.
First of all, I have to thank you for asking me this question, because I've been speaking to this country. I've been speaking to the deans of law schools in this country. I've even spoken to the chairman, Law Society. Yes. And I've also raised this issue with the Attorney General's office, that it's high time, it is time now and not tomorrow, that immigration law, comparative immigration law, should be taught. And lawyers should practice immigration law in this country. Immigration law has become very wide. It's the coordinating point between goods and services, or movement of goods and services from either way. Mm-hmm. Now, if you look at the way lawyers buttress themselves in court, purporting to know what they were doing, in my view, even though I'm not condemning them, in my view, they ought to have spoken from the same script. They ought to have looked at and sought advice from experts, because it's not taught in this country, and no lawyer in this country purports to know what immigration law is, apart from applying the principles of constitutionalism. Now, having said that, I would like to take this template and say that the Miguna's issue is a throat hole. It's an issue that should not be looked at just that way. When he says that he did not revoke his citizenship, if you look at Article 16 in this country, it automatically says, whether under the old constitution or under the new constitution, that citizenship can revert automatically, and particularly to a Kenyan who was born here by birth, or if one of the parents was actually a Kenyan citizen. Mm-hmm. If you look at the immigration law and the development of Immigration Act, which is derived from the common law principles of the United Kingdom, the 1948 British Nationality Act stipulates very clearly that no one can lose a place of his or her birthright. Mm-hmm. Therefore, by the state coming up and usurping up its power, by the Interior Secretary dreaming and coming out on his own volition and writing a letter to revoke the citizenship of Miguna, is actually paramount to a very grave disorder. And I would like to ask the United States government, the British government, and the Canadian government to put on hold traveling restrictions on the Interior Secretary, because he has come up and become very contravenous in such a way and manner that he has taken this country into a despotic state and is letting down the president. I like the president. I have not hidden my liking for him for that. But the Minister for Interior should reevaluate himself. He should not become autocratic by usurping up powers and letting the country into what it is today. These demonstrations are here because of Mr. Matiang'i. These demonstrations by lawyers are here because of his autocratic behavior, by pinning down things to abrogate and actually abuse the privileges conferred to him by the Constitution through presidential appointment, by becoming an errand boy of what have you. Right. And thank you for that.
Thank you very much. Let's hear from Mrs. Sam. Good morning. Good to see you.
Morning. I think from the civil society perspective and representing an institution that has been working on improving of good governance in this country for a long time, we always forget. I think, let me start by a disclaimer that it's very healthy for various organs of the state to engage in constant conversations.
Yes.
But we will all appreciate that since our Magna Carta moment in the year 2010, and after, particularly after the elections of 2013,
Yes.
we started seeing confrontation between various organs of the state.
Yes.
And at that particular juncture, some of these organs were alleging interference. For example, they would allege the judiciary is interfering with our operations, this being the legislature and the executive. And that has persisted. However, it is also noteworthy that all these organs derive their authority from the law, so that these organs are all equal organs: the executive, the judiciary, and the legislature, and none of them is superior to the other. Now, this is the conversation that we are having, irrespective of the triggers of the current standoff and the current action by the Law Society and its members.
Yes.
And I think we always have to remain alive to the fact that there is no absolute power. It has no place in our current constitutional dispensation. And maybe the recent events that we witnessed last week is an indicator of autocratic tendencies and behaviors
Yes.
of individuals that have failed or refused to appreciate that Kenya is a country that is governed by law, and that they as state or public officers are expected in mandatory terms to promote constitutionalism. So the law cannot be applied in a partial manner. Duty bearers, being state officials and public officials, have a higher expectation.
Yes.
They earn their salaries from our taxes. They derive their authority from the law. The executive sought to uphold, protect, and promote the Constitution. They have to lead from the front. So in however as much as we have individuals disregarding the law,
Yes.
our duty bearers have a higher responsibility. And the Kenyans expect that, and that is not negotiable. And I think that is why the fraternity of legal practitioners are engaging in these very visible actions, because if the duty bearers start disregarding the law, then our own social construct, it is actually amounting to security threat, because you will not expect the citizenry then to uphold, promote, and protect the law when duty bearers themselves engage in cherry picking, so to speak, which law they would respect or promote and which one they will disregard. Yeah.
Oh, thank you. So let's say from Karanja Kabage, first of all.
Yes. I think I have had an opportunity to look at the affidavits
Yes.
that have been signed by the Director of Immigration. And one of the reasons or the main reason why I understand Miguna was deported, I'm not talking about disregard of the court order.
Yes.
I'm talking about the aspect of deportation of Miguna, was that having denounced his citizenship when he became a Canadian, in the current constitution of 2010, Article 14 of the Constitution, sub-article 5,
Yes.
seems to have been the basis on which the immigration took their action. And it says, and I quote, a person who is a citizen who is a Kenyan citizen by birth, and who, on the effective date, has ceased to be a Kenyan citizen because the person acquired citizenship of another country is entitled on application to regain Kenyan citizen. Okay. That's what it says. Now, I looked at that, and I think it's in public domain. If you go to the court, you can find this affidavit, and attached to it, you will see the travels in and out of Kenya by Miguna.
Yes.
He never used Kenyan citizenship, even though in 2009, he was issued with a Kenyan citizenship. That's notwithstanding whether it was issued in accordance with the law or not. He never used it. He used Canadian passport to move in and out throughout. That's what it's showing. But more importantly is that we need to interrogate, and I'm talking about post-2010 constitution, whether Miguna complied with the Section 5 or Article 14, sub-Article 5 of the Constitution to apply for regaining of the citizenship. Because remember, prior to 2010, we never had in our old Constitution dual citizenship. What we had is that if you are a citizen of any other country, you cannot be a Kenyan citizen, which is, of course, the converse of what is happening today. Because under 2010 Constitution, you are allowed to be a citizen of any other country and still remain a Kenyan citizen. That is something that is really very important. But I have not heard people addressing this particular article, sub-article 5 of Article 14 on the citizenship chapter. That is an issue that I have not heard being addressed. So I don't know, and this is a matter of evidence,
right,
whether Miguna Miguna made an application,
right,
to regain his citizenship and therefore become a dual citizen, a Canadian and a Kenyan. That is the issue that I have seen from the affidavit that has been signed by the Director of Administration talking about
right,
his citizenship.
All right, and I can see his smiles writ large on Apollo Mboya's face, just to tell us, maybe, because now since I have all his learned friends of mine here, it's good to pick up also some of his aspects from the Constitution and bring some clarity and elucidate it very well for our viewers to understand truly where are we at as far as this is concerned. And of course, not delving deeper, looking at the merits and demerits because of a sub judice rule and the merits in court today as well.
Yeah, thank you. Actually, that is the caution I wanted to throw to my learned colleague.
Yes.
Kabage. I'm on record on that matter.
Yes, yes.
And the question before the court is whether citizenship by birth can be extinguished at any time. So I would not want to
extinguish even by myself if I revoke it. Does it nullify?
Yes. At any time.
At any time.
Can it be extinguished? That is the big question. Let me just put it. I'm just putting it broadly. That is the main question before the court. That citizenship that is conferred by birth, not by registration, by birth, can it be extinguished by any action, by any other person, if the person has not expressly renounced? So that is the main issue before court. So I would not want to really delve into it because I'm on record on that. And it's going to be interesting to see the decision on the court. And what my learned colleague Kabage has stated is correctly what is in the law, what he is saying.
Okay.
But there are various interpretations to that particular aspect because these are a number of transactions that also took place. Remember, Miguna also was a candidate here for gubernatorial seat.
Yes.
And that position can only be vied if you are a Kenyan citizen. And then the state has got all the instruments that it has in vetting and still say that he qualified.
Yes.
Even the electoral body. Miguna also has an ID of Kenya. Okay? So all these issues, and as rightly put by Mr. Kabage, how he got that ID, or if the Kenyan passport, if any. Those are questions that we are going to interrogate vis-a-vis the question that I've just put broadly. Can your citizenship conferred by birth be extinguished at any time if you have not expressed it
All right.
openly that you have renounced?
Okay, fine. Thank you. And I think we don't want to really dwell on that, but we want to broadly look at the state of the judiciary as well. But I want you just to make it limpid also for our viewers, Professor Wajakoya, what is being raised briefly so that we can wind up on it and then we move on.
The issue of judiciary is actually within the prerogative of the Constitution. And the President, as the head of the executive, has all the powers donated to him by the people in this Constitution to actually appoint judges.
Just to wind up on the case of Miguna Miguna,
yes.
that Paul Mbowe is raising very briefly. Then
when it comes to Miguna Miguna, leave that matters to me, because I am very sure that a lot of lawyers have not dealt in depth, especially when it comes to comparative immigration, which I've practiced in the US and UK, given the fact that I have higher education in both areas, a Master's of Law in Immigration from UK, SOAS, and another one from Immigration in Baltimore, University of Baltimore, and a practitioner in UK, which includes North Atlantic, Canada included, and EU. Issues of citizenship in Canada or Canadian citizenship are three-twined. One, citizenship by birth. Two, by acquisition within the Dominion. That's where allegiance is owed to the Queen, to the Dominion of Canada, New Zealand, Australia, which says that anyone born within those dominions automatically gets the citizenship of member states of the Dominion. Then there is also citizenship which comes in as a result of any other state, any other state in which category Miguna's case falls into any other state. Now, how did he acquire citizenship of Canada? It's very clear that when he left this country, he left as a refugee, and when he arrived in Canada on documents which were temporary documents granted by whichever body it was. In this case, it must have been the UNCHR. And it is through that process that he became a citizen. Now, from what my learned colleagues are saying here, senior to me in practice in this country, which I agree with and support, and them having looked into the affidavit, it is actually insinuated in one of the affidavits that Miguna renounced his citizenship. Now, how did the Director of Immigration come to a conclusion that he renounced? Did he actually penetrate the Canadian government? Did he ask the Canadian embassy to actually did he use the process? Did he go through the diplomatic channel? Did he go to the Canadian courts under the Official Secrets Act to actually extract that document, that application form that Miguna actually signed saying that I renounce to be a Kenyan citizen? Now, how can what kind of supersonic speed did he use, given the fact that the matters were so grave? Miguna was deported within 24 hours of arrest. Come on, let's call a spade a spade. There is an issue which is underlining the whole process, and I'm hoping, and I'm willing, and I'm saying that the state interfered with it. But now, coming to the Kenyan side, if you read Article 16, it's very clear. That one I'm not going to go into it. If you go into the old constitution where Miguna fits in, there was nothing in that constitution apart from what my senior counsel has said, that if you lost citizenship by renunciation, I think, then the matter was very grave. But remember, finally, remember that in the UK, it matters not whether you renounce your citizenship or you don't renounce your citizenship. All you do is to go back to Her Majesty's government and revert back by even going to fill in the forms, so long as you can prove that you are a British national.
All right, thank you. All right, unless you want to weigh in on that, we can actually rest the matter. But yeah, let's now peel back to what has been happening also this week with now the resignation of also the Attorney General, the former immediate Attorney General, that is Professor Githu Muigai. First of all, most pundits are saying this was long overdue, that yes, he was in that office, a frustrated man. He was not really accorded the support that he should have been accorded from the various state organs that were to enable him, work smoothly in that particular office. And so this was actually a writing on the wall that was just waiting to happen, hanging on a stroke of a rope. And finally, it now snaps, and there we have it. The news of course, development that we have that Justice Kihara has to take over as far as we're concerned as the Attorney General. First of all, can we talk about it? I know you've been in this particular fraternity for long, and you know what happens, some of the grapevines that you hear. Was he a frustrated man?
Let me start by observing that the Attorney General, the Honorable Attorney General, serves at the pleasure of the President. There is no security of tenure, and as such, the Attorney General who just resigned has actually served 2 governments, having been appointed during the Kibaki regime.
Yes.
From a legal practitioner's perspective, I would say that the kind of mishaps and goofs that we have seen with the executive, either in litigations in court or in certain administrative actions that have been reversed by the courts of having been unconstitutional, would point a finger directly to the office of the Attorney General, being the chief legal advisor to the executive. Now, one cannot really tell as to whether his advice was ever taken into consideration or ever sought. But the events of the last 4 to 5 years would lead one to a conclusion that either he was not effectively exercising the functions of his office, or he was doing the same, but nobody was listening to him. So to that extent, I would say that the President is within his rights to appoint anyone as Attorney General. Another critical pointer is the Attorney General defends the government in very many cases in courts. And one observation that we have made is that the office of the Attorney General is very quick to settle matters that are commercial in nature, while human rights violations and judgments that have been made against the executive go ignored. And one would wonder, you will all recall the settlement of the Anglo leasing that was processed without parliamentary approval. So to that extent, when you look at how that office has been run, maybe it was long overdue. Maybe it was the right time the President thought in his wisdom that he needs a new advisor moving forward in the few years that are remaining in his term. Yeah.
All right. Many parties also do claim that what really occurred on the August the 8th and aftermath of that, with now the nullification also of his win, that would have actually also brought to bear this particular predicament we have, or the resignation of Githu Muigai as well. Do you think there was any pressure that was bear upon the Attorney General as far as that is concerned, from your estimation? Let's say from Apollo, I will come to you, Sam.
Thank you. I was a state counsel in that office for 8 years. I know how it operates. It's not an easy job. First of all, you'll realize that the way the state is crafted, there are several other legal advisors put purposely, sometimes working in parallel with the Attorney General, and it can be frustrating. Here I'm talking about, you're aware that Abdikadir was in State House as a legal advisor on constitutional matters, also advising the same presidency. You have a Solicitor General who has got the ear of the President, and traditionally that is what happens, who sometimes also gives advice directly. Then you have the Attorney General. The Attorney General is not only the legal advisor to the government, but actually should also be a public protector. That is something that never comes out. He is the foremost public defender. And in our profession, he is also the titular head of the bar. So that kind of it's a big hat that he wears, which he must balance. And I agree with Sam that being an advisor, your advice can either be taken or be listened to only, and then calibrated with other advices that are coming from other people also within the government and outside the government, because that's how it operates. The president has got advisors all over, even on legal, even other practitioners, legal practitioners, who also lend some of their weight in any issue that come. So it is not an easy position to have. What I can say is this, and Sam has actually said, it's at the pleasure of the president. The Attorney General, traditionally, even worldwide, must be an ally of the president. And anytime a president loses confidence in the Attorney General, anywhere in the world, most of the time, is that the Attorney General will be on his way out. And that's what I can say at this time. As an individual, an impeccable professor, yes, you cannot doubt. And even the contribution is given to the legal profession, because I know, even as a private practitioner,
yes,
he was in the disciplinary committee for a very long time of the Law Society of Kenya, helping in ensuring that there is discipline and order among the legal professional. He's been a judge of the African Court on People's and Human Rights. So he's
a consummate lawyer.
Yes, and he's been a teacher. He's a great teacher.
Okay.
Yeah, he has taught many of us.
All right.
Yeah.
Maybe we could actually question now the fact that we had Abdi Kadir, who now has been commissioned as the ambassador of Kenya to South Korea, and having the Solicitor General as well. Do you think maybe the passing of his head, directly listening to the Solicitor General, as it is in the public domain, that yes, we know the Solicitor General, and who is now the Deputy Chief of Staff, has been the president's buddy since when they were in the Ministry of Finance as a personal advisor, right? Could that also had played into in the hands of what we can now see, because instances of where you don't get to hear what the Attorney General has to say, you have another advisor, legal constitutional advisor, who is acting, in the name of Abdi Kadir as well. Could that have also frustrated Githu Muigai? Apollo, before we go to
Nje Muturi has been with the president for a very long time.
Yes.
Even when he was the leader of official opposition, he was his personal assistant. So they come a long way. The intrigues of the office, all of us here can only speculate. The rest we've had from the press, but I cannot say with certainty of any frustrations that could have occasioned because of all these other personalities,
yes,
who are also giving legal advice. Because you must also give it to, you don't want to assume that the person who is receiving that advice has the capacity also to know that this advice, I've listened to you, this advice is good, if I balance with this, he's an intelligent person also. So you must also, as you listen to everybody, which is normal, as an individual, as the person who is going to take the ultimate decision,
yes,
you are capable of discerning what you can take from every advice that you receive, and then you take the correct decision.
Mr. Kabage.
First, I want to defer to Professor Githu Muigai, because he taught me jurisprudence and legal theory at the master's level at the University of Nairobi. And I want to agree with Apollo. He is definitely a very good teacher.
Yes.
Having said that, we must appreciate that he deals with very weighty issues. Attorney General of any country, and particularly in a country like Kenya, to serve for 6 years is quite an onerous responsibility. And in my mind, I believe that he has done his bit, and it is very difficult for us to know the working of the Attorney General in terms of the legal advice he dispenses to his principal, and why he has reached a point that he said, I have resigned. My take is that that job is not a job that is that easy. We had Amos Wako doing that job for 19 years.
Yeah.
The longest serving Attorney General. Prior to that, we had Kamere, we had James Karugo, we had Muri, we had Attorney General, just, what do you call, Jonjo. It's a very difficult job to deal with because it is both technical and political. It's technical in the sense that law is not everybody's cup of tea. And you have to advise a person who is politically inclined in doing things. And sometimes there can be a contradiction. And under those circumstances, we must say having himself for 6 years, it is a distinction.
Yes.
And unless he came out himself and confessed what led him to make the decision to resign, we can just speculate. It's a matter of conjecture on our part to determine what is the reason. All I can say, we have his replacement, a legal pedigree, because he has been a practitioner of law. He has been a principal of the School of Law.
Yes.
He has been a judge of the High Court. He is a judge of the Supreme Court. Now he has been appointed the Attorney General of the Republic of Kenya. I'm talking about Justice Paul Kariuki Kihara, or Kihara Kariuki.
Yes.
Now, I believe with the kind of requisite exposure, experience that he has, we have a new Attorney General whose standing in terms of experience is one that hopefully will serve the nation to the best that is possible.
Yes.
And we move on. Otherwise, at this point in time, my take on it is to say, I wish my professor, I always call him Mwalimu, Professor Githu Muigai, all the best in his new dispensation, as it were. And I believe that he is a person that has a wealth of experience and knowledge that will be relied upon in a way of consultation.
Thank you.
All of us, particularly me, I'll tell you, I always took pleasure in having time with Professor Githu Muigai, not as my lecturer, but in post that position.
Thank you.
Yeah.
All right, let's hear from Professor Wajakoya, briefly.
All has been said, and it has been said very well by the panel. I can't add much on what they have said, and I will respect what they have said, and I stand with what they have said.
Right, thank you. Let's move on, and we gravitate towards now even the constitution of a Judicial Service Commission, because of course we know we have Kihara, who was part of it as well as a president, and we need to know, was it the president? No, the CJ is the president of the Judicial Service Commission.
The CJ is.
The CJ is.
But Attorney General serves in the JSC.
In the JSC, he does.
Yeah, he does. Yeah.
All right,
he's
so
a member.
Yes, and we have new appointees right now. My question is, because the name that has been forwarded is one of the former Cabinet Secretary, Felix Koskei, amongst others as well. Do you need maybe a legal bearing, or maybe a background experientially, or none at all? When actually coming to this, and first of all, we know Felix Koskei was a former Cabinet Secretary. He's not been, of course, reappointed by the President. Also, is this sort of a pacifying position that is being given by the President?
Okay, I will,
a solace one.
I will not comment about the individuals proposed, but the position of the law is such that there are two slots within the Judicial Service Commission, that are supposed to be from members of the public.
Members of the public.
And there is no prerequisite such as legal background or anything like that. So to that extent, there is no problem with that. So there are 2 vacancies that represent members of the public, and I think those are the positions within the JSC that the president has nominated 2 individuals. And in addition to that,
of which you don't really want to discuss, because we know you've not been, maybe also from that particular docket you started to be a dysfunctional figure, and then you're taken to another docket as well. Do you think that will in any way bring a discernible difference that is diametrically different from what you've done with the docket of maybe the agriculture, like we saw before?
You see, for starters, these individuals are expected then to be subjected to vetting, and if there are issues surrounding their suitability to serve as members of that commission, then those issues can be brought to the attention of the relevant body that will subject them to
we have
vetting.
Our public baraza here to vet as well. Yeah, you, as a general public, this is public participation, which yes, as well. And
you see, these are the systems in place.
Yes.
The head of the executive, the president, is within his powers to nominate individuals to represent public interest within that commission. So there are 2 slots. The third one is a replacement of an individual who has since been nominated to the position of cabinet secretary, and that is a slot reserved for the Public Service Commission. So those were the 3. The Attorney General automatically becomes a member, so that does not require a nomination. So to that extent, should Justice Kehara be confirmed as Attorney General, then he automatically becomes a member. Maybe what might be critical and important is the timing of all this, bearing in mind that it all happened on the same day the Honorable Attorney General tendered his resignation. And to that extent, one then would deduce that, one, the executive moving forward is reorganizing itself. Maybe they have come to a realization that they need to strengthen that part by having a new Attorney General, a new Solicitor General, and also new members who would represent the public interest into the Judicial Service Commission. However, I would say that the coincidence is just too abrasive to some observers, including myself. That cannot be just a coincidence that occurred on one day, all these things happen. However, we wait to see, because the executive has its own agenda, and as people who think positively, I think then the agenda should be in great public interest. Whatever the executive is trying to do should be in great public interest, and for purposes of further fostering the culture of respect of the rule of law, and strengthening the independence of the judiciary. I hope that is the intention.
all right, let's hear from Apollo.
I want to trace back to what the president said, we shall revisit. And I'm saying this because it is now clear that the whole of the justice sector is being reconfigured. And I'm saying this starting from the Director of Criminal Investigation,
Yes.
the DPP, now the Attorney General and the Solicitor General. And we are also seeing moves now within the Judicial Service Commission. And the Judicial Service Commission is the one that deals with the recruitment of judicial officers, also recommends to the President in case there is need to constitute a tribunal to investigate the conduct of judges,
Yes.
but also has got the powers to deal with the question of disciplinary issues with respect to other cadres of staff of the judiciary, magistrates, and the support staff. Now, if you look at all of that, vis-a-vis the coincidence that he's talking about, Sam is talking about, there's a letter now that has also come from Tuju into the mix.
Yes.
Which to me is laying a basis of something that is dramatic that's going to happen in the judiciary very soon.
All right, so the president is making good of his promise, we shall revisit. And so we're seeing all the hallmarks of revisiting happening right now.
Well, I think, let's face it, you know, one of the things that Kenyans have not quite been able to assimilate is that we have a presidential system of government, like you have in the US.
Yes.
And changes to positions like the one that have been referred to as the Director of Public Prosecution, changes like the one of the Director of the Criminal Investigations, even Solicitor General, Attorney General, and the likes. They are normally not permanent. You will serve at the pleasure of the president in majority of cases, except for obviously Director of Public Prosecution, who has a tenure of office. He serves for 8 years, period. But of course, you can resign. We as Kenyans must be used to the exercise of prerogative of a president to reorganize his government the best way he knows why. How? Why? Because at the end of the day, delivery of the service by the executive, the backstop to the president. And the president must not be held to ransom by any public official who may be serving, unless you have a permanent tenure of office, you have a tenure of office. He can change, and there should be no issue of us leading too much into it. It's just that in this country we are not used to changes. People almost assume that once you're in the public office, it is a permanent office. It is not a permanent office.
Yes.
You serve at the pleasure of the president, because ultimately that's what the Constitution says. So in this respect, I would like to say that when the president said that we shall revisit, it is subject to interpretation or misinterpretation, or we can look at it in whichever we want to look at it. But I think if anybody was a president and you see Kenyans are complaining about, for example, corruption,
Yes.
where we have no successful prosecution that has taken place. And there are two very important institutions in the land that have to do with that. That is Director of the Director of Investigations,
Yes.
and the Director of Public Prosecution. These two offices are so important in reining in individuals that may be alleged to be corrupted. Now, Kenyans are always complaining that there is no conviction that we see taking place. And sometimes people can blame the judiciary, rightly or wrongly. But to the defense of the judiciary, if you if you present a case that is weak, it is not the judge's job to just convict.
Yes.
You must bring compelling evidence
Thank you.
that will make the judge do the conviction. But all in all I'm trying to say is that there is nothing extraordinary unusual in a presidential system, and we have seen it in the US where changes take place.
Thank you.
Yeah.
All right, let's hear from Wajakoya, even as we're winding up your 30 seconds. This particular expectation also from Justice Kihara is big. You mentioned that yes, he has a pedigree, an impeccable consummate also advocate of the High Court, that he is a senior counsel. Let's just hear from you as well as we're winding up. So we've not really drilled deeper and looked at what is really happening with the state of the judiciary. Also, when you look at small tenets like, trying to digitize their system as well, which has taken a long time as well. that has not been effected up to now. Is it a deliberate action? We've been speaking about this for almost 10 good years. So what is happening right now? From your final take, give us just 2 pointers.
This one, I'm not sparing the president either,
yes,
as much as I support him. I'm told that the Attorney General, the defunct Attorney General, Githu Muigai, is from Kiambu, so is Kihara. And that to me does not argue very well when it comes to issues of ethnic balancing, even though he has the prerogative to appoint whoever he wants. But such an appointment, to me, calls into question a lot of things. And secondly, the issue of Tuju. Tuju is known to have had a grudge with Raila Odinga. Tuju is a person I have respected for a long time until today. Mm-hmm. I will no longer respect him because of what he's taking on the judiciary. He knew very well that there was a mechanism of complaint through the courthouse. He ought to have advised the lawyers who are representing Jubilee at that particular time to exercise the remedies available in the courts of law. Now, by him coming out and pointing fingers as he pointed at Justice Odunga that particular time when he brought to reality that Odunga was related to Raila by virtue of his marriage and what have you. But Tuju is just trying to actually envisage himself to become relevant in this country. I'm sorry to go that way, but the fact is very, very simple. I will ask...
Briefly, we are winding up.
Yes, I would like to ask Kenyans in general to disregard Tuju's remarks because they are unconstitutional, and him being a minister in the current government, maybe he's trying just to do what he has to do. So my friendship with Tuju today is just curtailed. Thank you.
You disowned Tuju today?
Yes.
On air? Okay. Let's hear from Sam, your winding remarks as well. I think we should have another session where we shall just discuss, how the state is. We've not really drilled deep on that as well.
Yeah, the Constitution shall reign supreme.
Yes.
When the executive acts, it acts on our behalf. The resources they are expending are taxes paid by you and me. And I would always assume that when the executive is acting, it's acting in greater public interest. So my personal take is that so long as all these being done is done in greater public interest and it's within the confines of the Constitution, so be it. However, if that is not the case, and in instances where there is continued disregard of court orders or expressions being made by the executive that are contemptuous or condescending to any other organ, I think all Kenyans of goodwill need to stand up and say no.
Thank you.
Yes.
Thank you. Thank you, Sam. Let's hear from Apollo, briefly.
Yeah, I think we are at a defining moment in Kenya, where, to me, the rule of law is under threat. It behoves the judiciary to come down heavily on those people who act in contempt of its decisions. Mm-hmm. And it is only the judiciary that can still help in this regard. They must jail somebody.
They must jail somebody.
Yeah.
Karanja Kabage, briefly.
Yeah, I want to take exception to the reference by my good friend here, Professor Wajakoya, on the issue of Justice Kariuki being a Kikuyu, and therefore his appointment as an Attorney General is anything that should not have happened. I think that is not really right. The President, first and foremost, must appoint somebody he feels he has confidence in. Mm-hmm. It doesn't matter whether that person happens to be a Kikuyu or not. I have not heard anybody complain about the appointment of the Solicitor General, who is not a Kikuyu. He replaces a Kikuyu. What is the big deal about it? I think we must avoid this issue of ethnicizing everything. Because as a president, I want somebody who I can trust. Whether that person comes from my community or doesn't come from my community, in a position like that of Attorney General, I don't think it's something that we should begrudge him.
Thank you.
Yeah.
Thank you very much. I want to thank you, my panelists, this morning for coming through. I think we should carry on with this conversation. I think it has not been exhaustive. We are looking at all the merits that we should have actually drill deeper in. But I want to thank you also for your illuminary remarks, and of course really also enlightening the wananchi. And I don't know what's the yellow ribbon is indicative of. You normally have the lilac, or is it the purple ribbon as well? Today it is going to be the yellow ribbon. Yes. In protest against impunity and willful disobedience of court orders. Maybe another time you'll tell us why. And as I mentioned earlier, this particular procession will begin at Milimani Court at 10 a.m. All advocates, activists to converge there. Now, of course, they'll march through the Kenyatta Avenue, and endpoint will be Supreme Court, where sessions will be held on disobedience and enforcement of court orders and the importance of universal adherence of the rule of law. Dress code, they say, is robes, which is optional. You carried your robe today,
yes.
And suits, yes, and yellow ribbons as well. They say fidelity to the law is a solemn and patriotic obligation of all. At the same time also, there will be a meeting at the AG's office at 11 today. We don't know what that will be. Maybe also a farewell party for the former immediate Attorney General as well. Thank you so much, our panelists, and I also want to thank you, our viewers as well, for your valued company. My name is Debarl Inea.